Hi guys, I'm back. Fever's gone. Feeling so much better today. And we've got some spicy filings to go through. The first one is a response by my new favorite attorney in the case, Ellyn Garofalo. The last episode on documents that I covered was her document, her motion to compel. So since then, there's been a bit of a back and forth, and I'm sure you've probably heard about most of these, if not all of them by now, but I still wanted to give my take. I'm going out of order today, which is kind of rare for me, so it makes me wonder if I still have fever. But I'm starting with the latest one just because I love it so much. And I think it's good to know the ending when you're going through the ones before this, because they're irritating. And I just adore, I cannot express how much I adore this lady's style. I haven't met her yet. There are very few pictures of her out there. I tried to find a video of her just so I could hear her voice, because I'm a little bit obsessed, I'm not going to lie. But you can read so much about a person in their motions and letters. So at the end of the first paragraph, she lets us know that there's been some new issues that were raised by Van Zandt and Blake, and so the purpose of this letter is to address those new issues. Now she says in her answer and counterclaim, Abel contends that Stephanie Jones and her company Jonesworks collaborated with non-party Lively. And I was just like, this is amazing. She just coolly drops that. Just drops that like, non-party Lively. Oops. You know, she's all, oh, I didn't see you there. I didn't know you go here. You go here?
School. I wish that I could bake a cake made out of rainbows and smiles and we'd all eat it, be happy.
She doesn't even go here.
Do you even go to this school?
No, I just have a lot of feelings.
Okay, go home.
You know, just kind of letting the court know she had no business getting involved in this. She's not a party to this part, but she does it instead of the shrill way that Ezra and Mike Gottlieb do it. It's just a little, oops. And then she just continues. I swear there's some Southern in her because Southern ladies know how to tell you off with a smile and sweetness and hospitality for the sole purpose of obtaining documents that Jones pirated from Abel's phone and iCloud accounts. She's putting it all out there. Pirated, that's like when you steal music from the internet that's not from the source. It's just someone put it out there that you can download it from. That's called pirating. So it's unauthorized use, particularly in a digital format. That's a big accusation right there in one little word. And then just that mention of the iCloud account is just a reminder to the court about how serious this is. It wasn't a company phone that was retrieved and rightfully restored to the company that owns it. It was her intellectual property. It was her private property. It was privileged doctors' information and lawyers' information and intimate conversations. It was private, personal pictures. All of the things that they had no right to access, whether it was a company phone or not. There are limits to what a company is allowed, even on company-supplied devices. Even in companies that let you know right up front, when you're using your laptop, for example, we can and will be monitoring you off and on while you're working. But even when they're doing that, if they observe personal conversations, they're supposed to leave. They're not supposed to stay on and entertain those conversations. There are limits, even on company phones. But an iCloud account, you can't justify that in the smallest bit. That's not even technically a part of the phone. That's why it's called a cloud. You access it by the phone, but if it's not your cloud, you can't access it by any phone. Another point she makes, and it's all just so cool, without waiting for discovery in anticipated litigation. And this is where I think they're going with it. I did those 2 videos a couple of months ago when the subpoena was finally discovered. And I went through the steps of how you're supposed to go through a Doe lawsuit. It's outlined very clearly. There have been cases taken to the appellate court, cases taken to the Supreme Court. They didn't put those regulations in there for nothing. Just so someone could say, well, I don't want to do that, so I'm going to do this. And little by little, they're dropping clues that that's exactly what they're talking about. I've been stockpiling some cases. I'm going to make a 3rd follow-up because people don't seem to get that what they did is not okay. That there is a standard that's set forth in New York that you're supposed to follow to do a Doe lawsuit. Like I said, it's gone up to appellate courts. The higher court's rulings are what I'm looking for specifically, but it's all there. And I'll tell you why, because what Blake collected is discovery. No way around it. A subpoena to get information is discovery. Now, we just went through a lawsuit in federal court, and you saw the steps that it took to get to discovery. Remember, it felt like it was never going to officially start because that's the rules. Now, state rules are a little bit different. In federal, no discovery, it says it right in the rules. No discovery can be demanded until after parties have conferred, and that's the federal rule 26F, after the meet and confer. Now, in the NewYorkCourts.gov, it says that in state court, it's usually after the interrogatories and the meet and confer. There were no interrogatories served because there was no defense. There was no opposing counsel. There was no judge. There was no one but a defunct company. She goes on to say, Lively admits that the Van Zandt action was a sham contrived for the sole purposes of obtaining Abel's text messages as part of investigation preceding Lively's filing of her claims against the Wayfarer parties. They're not letting this go, and I love that every time they say Van Zandt, there's the word sham. She mentions again, and we went through all of the things that the subpoena was supposed to cover. She pulled back 6 of the 11 demands, so more than half. She's been very reasonable. But there's still some things that are wanted, and they have a right to know. This is the company that filed a lawsuit to take her stuff. She has a right to know who sued her without her knowledge. So they want to know who owns it. Is it owned and controlled by Blake and Ryan? There's very little information out there about this company. She wants a copy of the subpoena that was served on Stephanie. All of the documents that subpoena brought forth. And they say Van Zandt objected, but Van Zandt should be required. They literally started the whole thing. And then they talk about the contradiction in Van Zandt's answer. On one side, agreeing to produce documents that are responsive to requests 1, 4, 10, and 11, which they say is proof of Van Zandt's ownership, obviously, if they can provide those. And it also proves that the documents that Stephanie produced are relevant and discoverable. By saying they're going to hand these in, they've withdrawn their objections. So how are they still holding an objection for number 9? And number 9, very importantly, is Van Zandt's communications between and among Jones, Lively, and Van Zandt or their counsel relating to the Sham Van Zandt action and subpoena. I mean, did Blake really believe she wasn't going to have to produce these things? You know, it's like a kid that sees a cake and they want it and they don't want to wait, and their mom says, no, you can't have it till after dinner, but they just keep looking at it and they want it now, and they eat it and they don't think about the future until they've eaten the cake, their hands, their face covered in frosting, and they're sitting here going, how am I going to deal with this? Well, I'll just say I didn't eat the cake.
Who had the cake, the blue cake? Huh? Who did it? Who had it?
A father?
You didn't have no blue cake?
No.
You didn't have no blue cake at all?
No.
Okay.
That's how realistic Blake's viewpoint of this is. I mean, she's like a child that's never been held liable for anything, never been held accountable, or had to obey anyone or anything. Then it goes on to say that the reply also addresses the objections that Lively, a non-party to the Jones action, I love that again, non-party Blake, has gratuitously, another classy word, asserted in her letter seeking to intervene or the court's permission to file a response. They're like, she doesn't go here. She has no say in this. Then she says that Van Zandt asserts the same hollow objections, that these communications are irrelevant and not discoverable because they're available from Stephanie Jones. It doesn't explain why they continue to object on grounds that it's waived for everything else. And Van Zandt decided that Abel's already received the only relevant documents from Lively. So why should we have to do anything? You already got them. But they didn't get request number 9 from Blake. And just like I said last time, there's no way they can say this is unduly burdensome. It's 2 documents. And she's saying, oh, she already gave them to you in a purported action. Well, then it wouldn't be hard, would it? And they point out, in other words, Lively is Van Zandt. And there can be no legitimate contention that it is unduly burdensome for Van Zandt, i.e. Lively, to produce the communications responsive to request number 9. So it makes no sense. But the bigger question right now that people are finally starting to ask that we talked about a long time ago. I remember making the thumbnail of Blake and Stephanie Jones laying in a bed like they're having a slumber party and borrowing a subpoena from one to the other. But the problem I raised then was this whole chain of custody, the weird way that things were collected. Did Stephanie just give her a stack of paper? And then how did it go from Van Zandt to Blake? Normally, in a Doe lawsuit, any information you obtain like that stays in the lawsuit, and then as you learn the names, you fill in the names. Doe is just a place marker, and the lawsuit continues in the same court. But because this was all a sham, that's not who's currently suing. So how did it get from Van Zandt to in Blake's hands that she could distribute it to the New York Times? And the next line too. Nor can Van Zandt argue with a straight face that communications relating to the coordination between Jones, Lively, and Van Zandt relating to the Van Zandt action and subpoena are irrelevant, particularly in light of Van Zandt's implicit admission that all other documents are relevant and discoverable. Ellyn knows what time it is. She knows exactly what went down, and that's why they don't want to hand it over. They're handing everything else but that, hoping that keeps somebody happy. They've been holding out for motions to dismiss, and mostly got them. They thought they weren't ever going to have to turn this stuff in. Judge Blake's daddy hasn't granted the motion to dismiss on this one yet. So this little stall tactic, it's going to fail pretty soon. But I love the straight-faced comment. It's like she's saying to them in her calm, cool, and collected way, she's like, you know what you did. And you know that I know what you did. So how are you even saying this to me with a straight face? 'Cause we know. And then they go on to say that it's the whole crux of Abel's claim that there's this conspiracy, this sham lawsuit to get stolen information. She's using the big words now. Stolen information, pirated. And that this lawsuit was to provide a veneer of legitimacy for this transfer of stolen information. She's not playing. Brian kept saying he was getting more information. They've been very, very quiet. They still keep getting accused of running to the media, but they haven't done that in a very long time. It's been Blake doing that, not these guys. They've been extremely quiet, and that's a good thing. You don't need to be out there blustering when you're sitting on a gold mine. They're as calm as can be. And she drives it all the way home when she says, "This is why I want it. I already told you, but I'll tell you again since you can't seem to get it. Such communications will also show whether, as Abel suspects, as her iCloud is probably already proven, Jones provided data taken from Abel's stolen phone to Lively before service of the Van Zandt subpoena, and the Van Zandt subpoena was a ruse contrived by Jones and Lively to cover up what they knew was a wrongful disclosure of Abel's communications." I'm telling you, she's using the big words today. This is big stuff. This isn't blustering. This is, I know what you did, so don't tell me you didn't with a straight face. And then there was a lot of fussing about this rule that they have to get this from parties, not from third parties. There's no such rule. And even we'll get to how they worded it. So funny. But they said there is no rule that party sources must be exhausted. You can send out subpoenas. You can have 10 people for depositions. You're not limited to the parties. It's ridiculous. And they take it further. Nothing in the federal rules of civil procedure requires a litigant to rely solely on discovery obtained from an adversary instead of utilizing subpoenas. And unlike Team Blake, when they cite a source, it's a legit one. The little footnote says Van Zandt did not explain why it did not agree to produce this plainly relevant and discoverable material during the meet and confer process, requiring Abel to file her motion to compel. They go on, Rule 45 does not require a party demonstrate that information cannot be obtained from another party before subpoenaing it from a third party. For the foregoing reasons and those set forth in Abel's motion, Abel respectively requests that the court enter an order compelling Van Zandt to produce all documents responsive to request number 9 in the subpoena directed to Van Zandt. And you know, when I was reading this, I think I was in like a fever dream because I was just like so admiring this woman. I just want to meet her. I'm going to have to show up at least one day just to hear this woman speak in court. But she's like, to me, she's like the Devil Wears Prada meets the Good Wife, you know? And I was looking at her experience, like what she's done in the past, and this woman is extremely impressive. And what's important is that she has significant trial experience. That's a big deal because a lot of civil cases do get settled. At most, they just have hearings before the court, but they may get all the way down to the day before court and end up settling. So finding a civil attorney that's actually done significant trials is a good thing. I love a trial. I love a trial. Every moment of it. I'm never early for anything, and I'm early. I even love the sounds, like the terrible microphones. There is not a courthouse in this country that has a decent microphone. Every teenage TikToker in this entire country has a better microphone than the courthouses. But somehow it just matches. I hate this part of a lawsuit. It's all paper, no humanity. I know I say that constantly, but it really drives me crazy. It's just rules and no heart. But once it's in the hands of a human jury and the attorneys have to stand up and present as a human, and you get to watch them and read their face when they're talking and know when they're lying and when they're not and when they're scared and when they're not quite sure what to say. It's such a rush. It's such a moment to me. I'd rather watch it than a movie. But just by judging Ellyn by her picture, and that's why I can't wait to see her animated in video or in person or something. But just looking at her, she's like class. Just the right amount of makeup. It's not overdone anywhere, but it's neat and it's pretty and her hair's pretty. And what's so rare, so rare, my Murdoch crew will know when I say Miss Limehouse. It's so very rare to see, but you see it on Miss Limehouse, and I saw it on her. A genuine smile. I can tell a fake smile so fast. There are so many parts of a fake smile. And there's something about a real, genuine smile that just makes you smile, even if you're just smiling inside. And I feel like it says a lot about a person, because when you lose your ability to genuinely smile, well, I don't really want to finish that sentence. It sounds very judgy, but I think you know where I'm headed. So if someone can still genuinely smile with joy, I think they're still doing good in the world. Let me put it that way. And the fact that she handles some criminal stuff. For Miss Limehouse, I know it's getting the bad guys, and that gives you a sense of accomplishment and true justice, and like you've actually done some good to the world. But I need to dive into Ellyn's experience a little bit more. But I feel like she's not going to suffer fools. I look at her and I think she's a fine lady, and I feel like when she's dressed up like that, I feel like she'd feel like I do when I dress up. If I'm going to do the whole got somewhere to go, got to dress up, got to do my hair and makeup, don't make me sweat. Now, I'm not talking about playtime when you're out doing sports or whatever. I was always that girl. But when I'm dressed up and I got my hair done, don't make me sweat. Don't make the heat rise to the top of my head, because then my hair's going to get all wild and curly. I was just looking at her there with her alabaster brow, and I was like, this is a lady. She's not going to shriek. She's not going to be shrill. Remember hearing Ezra's voice? It was like, oof, nails on a chalkboard. She just came in so angry, and that's a big sign that you're actually out of control. That's a sign of weakness. It's, why are you screaming? Why do you think that you have to scream to get your point across? Is it because your point can't stand on its own without being shrieked? I like an attorney who's not all heated and shrieking, but who just drops their words like dry ice. Just cool, and you see that foggy looking stuff rising up off of it, just cools the room. When someone's screaming, you just kind of lean away, you don't want to hear it. It's annoying, it's too much. But when someone's speaking powerfully, but coolly, just nice and low, they don't raise their voice for you to hear. You have to quiet down so you can listen. That's power. That's power when everyone in the room's going, shh, shh, shh. I want to hear this. But that's what I've created in my mind. For no reason. I said, it was just some fever dream. I saw her picture, saw her smile, and I thought, you know what, Ellyn, come sit by me. I want to hear all about it. Now, I spent so much time on hers. I've got these others to get through, but they're not nearly as interesting. So we got Ezra. Speak of the devil. I don't have a chalkboard to scratch here, but you can just picture it. So I literally labeled this one in my computer Ezra Butson. I always start with the document number and then the date and then I name it. And so this one is Ezra Butson with that day's date and document number. So it's like she didn't even read the motion to compel. They clearly put the reasons, not just what they wanted, but why they wanted it. They clearly laid it all out, and these people couldn't be bothered to read it. They just immediately start shrieking and smacking and hissing and repeating. And so she's writing on Blake's behalf to alert the court. Oh my goodness, court, are you alerted? She's like, Judge, Blake's daddy, save her. That the motion omits critical information that creates a materially misleading record. Really now. And she says that a copy of the subpoena and that the documents supplied from Stephanie to Blake via Van Zandt have already been given to the Wayfarer parties since May 16th. I didn't see a denial in Ellyn's letter, so I wonder if they do actually have it and just didn't realize it was probably handed over and buried. And it's really interesting to me that they didn't list the Bates number. We talked about that, a few months ago when we were talking about how the process was going to go of everything. And there was a document that mentioned how the electronic information was supposed to be stored. And remember, I showed you some samples of what Bates numbers look like and why they're used. They all have to decide, because everybody labels things differently. But for the purpose of the trial, they all need to match up so that when someone's speaking about a certain piece of evidence, the other side knows what they're talking about. They have to have the same labeling system. So it's called a Bates labeling system. And I thought I saw it in one of these documents today. But I remember making an episode about that. But this is exactly the time when you would use that information. You wouldn't just say, pursuant to an email on this day. There could be a lot of emails exchanged that day. There could have been a mountain of discovery delivered that day. So why not give the Bates number so they know exactly where to find it? So it makes me think it might have been like purposefully hidden if it was handed over. But the funniest part about this whole thing is this little footnote, I guess. It's not an actual footnote, but it's pretending to be a footnote. It says, we note that this firm does not represent Van Zandt for the purposes of the Van Zandt subpoena that is the subject of this motion. Do they think that everybody's just going to forget that they are, in fact, the law firm that filed the sham lawsuit and issued the subpoena for themselves? They're like, please don't confuse us with the law firm that pulled the scam off. Oh, wait, that was us, but we don't represent them anymore. That was so last year. You know, wealthy attorneys, we don't wear the same lawsuit twice. And then they're like pointing, oh, no, it's not us. It's that Zuckerman over there. It's Zuckerman. And this letter, it's not intended to be a response on behalf of Van Zandt because we had nothing to do with Van Zandt. We filed the Van Zandt sham suit, but that's it. That's where we stopped. That's not us no more. It's that Zuckerman guy. And you know what I couldn't help but think when I saw this out of place document? Blake is not a party to this lawsuit. This is Stephanie Jones and Jennifer Abel. Even Van Zandt's not a party. They're a third party that got subpoenaed. But Blake has nothing to do with this one. And here's Ezra's document sitting on this docket that it doesn't belong in. And I was just like, hey, Judge Blake's daddy, hey, are you going to remove this from the docket? And that sua sponte outrage that you had over Brian's misplaced letter in your docket? No? Yeah. I didn't think so. But a girl can hope. And then they included the email. And the funniest thing about the email is the finger pointing. So in the letter, they're saying, oh, it's not us, it's Zuckerman. And now in this one, they're like, it's not us, it's Stephanie. So it's everybody else but Blake. So this is their email to Wayfarer's attorneys saying that Blake's reproducing the documents. And then we get this interesting. It's like, well, I know we have an ESI stipulation, how we're supposed to turn this stuff in. And this doesn't exactly meet the designated standard that was decided upon for everyone. But you know what? I'm famous and the judge likes me. So you should just take what I gave you. And if you don't like it, it's Stephanie's fault. So because they didn't handle things correctly, these documents that were given from Stephanie to Blake don't have certain attachments. And without metadata, isn't that interesting? And without metadata contemplated in the subsequently negotiated joint stipulation on I'm not going to read all that long title of it. It's how they agreed that the electronic evidence would be given and stored and stuff. So they're saying, oh, there's stuff missing. It's no big deal. And it's Stephanie's fault. You know, what's a little metadata? And it really makes me wonder, what is this metadata, this missing metadata? Because do you remember Leanne's big discovery that kind of blew the case open? She discovered that the New York Times had, not only did they have thousands of pages of texts and emails that weren't part of any kind of judicial proceeding, but still somehow qualified for privilege, but that they had them as far back as October. And that was a huge deal. And so now there's missing metadata. Isn't that interesting? But I've said this all along. I've always had a problem with thinking of how this went. When you're serving a subpoena, you want your evidence to be as good as it can be, uncompromised, unadulterated. So you don't ask some angry woman that's allegedly losing her mind to give you a copy of what she got and feel like that your evidence is good, because you could be asking for a lot of trouble. If there's anything wrong and you can't vouch for it, you're in trouble. So the best thing to do, I mean, if you've got a subpoena, you take it to a legit tech company that extracts things from phones. Then you know you have pure evidence, authenticated, verified evidence. So now I'm picturing Stephanie in the way that Jennifer Abel described her around the time she was leaving. And I just see these rage-crumpled stacks of paper. Some got coffee stains on them. She was no doubt reading them and screaming, so they're probably spit-stained and tear-stained and a little runny mascara on them, maybe a smudge of lipstick. Who knows what this stack of papers has been through. But now that's all I picture. That's all I picture. Stephanie's got this stack in her office that she's just raged over and showed everybody else. And she just hands it over to Blake, and it's missing this and it's missing that. Because, of course, I mean, I could just, like, picture her with a little pair of kid scissors, like, cutting her name out of them. You know, just ridiculous. My mind went wild. Fever dream. Picturing the scene of what getting evidence from one allegedly psychotype woman to another. It's an interesting subpoena, and I bet it's the most interesting evidence that a subpoena's ever gotten. Lots of DNA on that, I'll tell you that much. And now we've got number 73. We have a John entering the scene. So he has joined the docket, and he starts off right out the bat. The motion appears to be yet another attempt by Abel and the Wayfarer parties to use the legal proceedings to continue their negative media campaign against Blake Lively and her associates. Listen here, John with no H. You literally just got here. Don't sit there and type this up like you've seen it all and you're exhausted. Okay, you just walked in. How fed up can you be? I'm getting really tired of them saying that. When is the last time they went to the press about anything? Compared to Blake. Seriously. And they still keep saying it every time. Nobody went to the news with this. It wasn't even filed in the main lawsuit. It's in this little one off to the side that a lot of people forget about. Ridiculous. Not cool like my Ellyn. She doesn't need these tired old sayings. She just drops classy words and we just sit there in the breeze of it all. Okay. Did these people even read the motion to compel? I mean, okay, he's got a little bit more of an excuse. He was literally parking his car and putting his pencils in his desk. Why did nobody help catch him up to speed on this? He's just joined us, but read the motion to compel. It wasn't long. They gave all the reasons. So most of his letter is arguing an argument that if he just read the motion to compel, he'd have all the answers to. They said why they need this. And then he keeps accusing Jennifer Abel of abandoning the meet and confer. Because you guys were just refusing. After a certain point, you give up. And you realize you gotta compel. And then he repeats the same stuff Ezra repeated. Oh, she's already gotten this stuff, and this stuff doesn't have any relevancy. And I swear, this is the part of the lawsuit, another reason why I hate it, is because this is where the attorneys become the cranky kids in the backseat of a car on a long drive. It's all, I'm hot, I'm tired, I'm hungry. He's looking at me, she's touching me. He started it, no, she did. That's all we get for the next couple of months. Over and over and over again. Then he starts fussing again about Well, we already gave her all these. Why does she need number 9? She wants them both. Read the motion. And if you haven't noticed, you're from the team Overbroad. And you're literally representing a defunct company that helped Blake illegally steal this woman's entire life from her phone. And you're stomping your feet and squawking about 2 documents and communications from an exchange that probably took 3 business days, and then the 2 women went on back to hating each other. How much communication can it be? This was a straight-up business deal. These women don't like each other. They weren't sitting around braiding each other's hair and chatting about the future. I'm telling you, 3 business days at max. Then they just want to keep complaining that she abandoned it. And meanwhile, she's right up there with Justin and Jamie for their accusations, but she was the most violated. And give this woman whatever she wants after what you did to her, and stop complaining about it. Can you imagine how she feels when she sees all this fighting of them trying to protect their stuff? Sitting there having every word she wrote to anybody she knows for the past how many years? And they're going to fuss? Oh, that's too much. You're asking for too much. Every time she had to give way to them, it probably went through her head. Nobody asked me if this was too much. Nobody asked me if they could have that. Nobody said, oh, okay, well, that's privilege. We won't touch that. And they can't even think about that. They're just sitting here fighting to cover up their crimes of stealing her phone's info. I don't think I could stand it. John with no H. And then they say it should be denied because she fails. Poor Jennifer Abel. She fails to demonstrate how the documents are relevant. How was her iCloud relevant? John with no H that just got here. Abel has a far-fetched theory that the documents are relevant to her amended counterclaims. Is it really far-fetched? Oh, her counterclaims, they're at the heart of an employment dispute with her former employer. It has nothing to do with Van Zandt. I mean, it's not Van Zandt that got the stuff off her phone, right? What does it have to do with Van Zandt? Wow. Are people this out of touch with reality? Is it a show? How much of your soul do you have to lose to write a document like this? Jeez. But she wishes she would have had the chance to say this when somebody was trying to get her stuff. And then they say, Van Zandt's not alleged to be involved in any way. This took place weeks before the Doe lawsuit was initiated on September 27, 2024. Wow. Crazy. You started the party, Van Zandt. You lit the match. And then here, I told you how they say the rule is so funny because Ezra was trying to say, you get it from the parties. But it's not the rule, so he has to say, it's been thought preferable. It's been thought preferable to obtain them from a party instead of a non-party. And he has to end it the way he started it, that the motion is consistent with Abel and her counsel's pattern of using the court's docket to advance public relations narrative in the media. Find one thing that Jennifer Abel has put in the media since this whole mess started. John with no H. Show us one thing Jennifer Abel has ran to the media with since you guys violated her. And now look up how many times Blake's been in the media. And Ryan. Idiot. And then he's like, well, to help resolve the dispute without further burdening the court, Van Zandt will produce its articles of incorporation. You really don't have a choice, though, do you? And written consents. And then has the nerve to ask the court to not make him give the stuff for request number 9. But if you knew that you were going to hand everything over, except for the one, what was the point of writing 3 pages worth of this document? Did you just want your moment to shine so the media gets to hear your name? John with no H? I had to look this guy up because his words are so sour and I'm like, this is not a nice guy. And his face matches his letters. So let's have a look. Don't you think so? All right, guys, a very non-serious review of the latest documents on the Jen Abel branch of this crazy tree. And like I said, I've been working on yet another, because nobody takes it serious, episode about these Doe lawsuits. And I might do a follow-up on 47.1 called Cassidy Claps Back. If you know, you know. Till then, this is Cassidy O'Connell saying stay well, I'm almost there, and stay tuned.